All right, good afternoon. Is this the last one of the day for y'all? Have you just been waiting impatiently for this to happen? Yeah, us too. Well, less impatiently. We knew we'd get here eventually. So, all right, well, let's get Connecticut wild here. So we'll introduce ourselves, have you introduce yourselves, tell us where you're from, and then we'll get started. I am Lieutenant Colonel Kurt Mabus. I'm an attorney with the United States Air Force, currently in Colorado Springs, where I teach law at the Air Force Academy, and I am an alum of the program as well. Richard?
Hello there. My name is Richard Leiter. I'm a professor and director of the Law Library at the University of Nebraska here in Lincoln, Nebraska. I've been judging the state competitions for about 15 years, and this is my first time at nationals. So very excited to hear your presentation today.
Canada, you're muted. Okay.
Yeah. It's also your first time at nationals, I expect, ladies. And my name is Candida Steele, and I'm retired as a judge on the U.S. Civilian Board of Contract Appeals. I handled federal government contract disputes around the country, and I've been a national judge and a Maryland judge for 20 years. Can't believe it's been that long. My great pleasure, and this is certainly the highlight of my year to do this program. So congratulations on getting here, and we can't wait to hear what you have to say.
Good afternoon, judges. We are Unit 5. Our unit focuses on the Bill of Rights. My name is Rachel, and in the fall, I will be attending Northwestern University studying theater.
I went to Northwestern. Congratulations.
Hi, I'm Joelle, and this fall I'll be studying environmental engineering at Northeastern University in Boston.
Good afternoon, my name is Madeline, and I'll also be attending Northeastern University to study political science, but this fall I'll be attending New College of the Humanities for a semester. But for now, we're all seniors at Trumbull High School. This is our teacher, Ms. Dolan, and we thank you for being here today.
Great, hi.
Right. Thank you all for being here. So no surprise to you, we're going to do question 2. I'll read the question and then turn it over to you. A Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on inference. Do you agree with this quote from Thomas Jefferson or disagree? What are the advantages and disadvantages of a national Bill of Rights compared to state bills of rights? What are the differences between positive and negative rights, and which are more important to the preservation of liberty?
If a constitution is the memorialization of the social contract, that is, the idea that we agree to submit to the state's authority upon the condition that the state protects our person and property, then the Bill of Rights is the people's security deposit.
A Bill of Rights is an enumeration of individuals' rights in relationship to their government. Though the highest purpose of government is the protection of the rights of the people, history teaches us that even democratic governments do not always live up to that solemn purpose. As James Madison said in Federalist 51, you must first enable the government to control the governed, and in the next place, oblige it to control itself.
Bills of rights are often critical in obliging a government to control itself. Thomas Jefferson wrote that a Bill of Rights is what the people are entitled to against every government on earth. We agree. Without this, the government could depend upon the sometimes ambiguous phrasing of its powers to trample on the rights of the people.
Throughout history, we have seen a need for a national Bill of Rights. For example, while Massachusetts lacked the rights to free exercise of religion and the right to bear arms, it guaranteed the rights to speech, press, assembly, and petition, which the charters of Rhode Island and New Jersey did not.
Without a national Bill of Rights, people in different regions of the nation would not be entitled to the same fundamental liberties. This would weaken the nation, as Benjamin Franklin once wrote, an equal dispensation of protection, rights, privileges, and advantages is what each part is entitled to and ought to enjoy.
It was not until the passage of the Reconstruction Amendments that Franklin's image of equal protection was legally established. No amendment has been more litigated in our nation's history than the 14th, which has been used to safeguard both procedural and substantive rights against states, as well as those rights both enumerated and unenumerated in the Constitution.
Thus, with selective incorporation, the Bill of Rights was used to further the rights of women, voting, LGBTQ+ people, and racial minorities. However, state bills of rights tend to list more specific rights, thus relying less on judicial review to establish them. And there we see the disadvantages of a national Bill of Rights.
In 1977, Justice William Brennan Jr. called on state courts to use their own constitutions to protect their own individual rights. Since then, some state Supreme Courts have granted more protections under their own constitutions than under the First Amendment, including those in our own state.
The Connecticut Supreme Court interpreted its freedom of expression guarantee to provide greater free speech protections to employees than the U.S. Supreme Court provided in Garcetti versus Ceballos in 2006. The court reasoned in Truce versus UBS Realty Investors in 2015 that there is no evidence to suggest that the constitutional framers of the Connecticut Constitution intended to impose such severe limitations on the speech rights of the state's citizenry.
The rights in our Bill of Rights, like the First Amendment, are largely negative rights. That is, they restrict the government from encroaching on a particular right, rather than obligate the government to provide it. For example, Americans are not required to engage in political speech. However, the government cannot restrict such speech.
Important positive rights exist as well. The Sixth Amendment guarantees that the accused shall enjoy the right to a speedy and public trial. Article 1, Section 10, the Contracts Clause, provides that the government must enforce and protect people's contracts.
We believe that negative rights are more important to the preservation of liberty. Without the ability to call out the government when it fails to provide the positive rights that are critical to a free society, such as the right to a speedy and public trial by a jury of our peers, there would be no guarantee of those rights, and the government would have greater range to do as it wished and abuse its power.
Jefferson understood that blind faith in government to safeguard our natural rights would ultimately leave the people exposed to the same fundamental issues that sparked the American Revolution. More was needed. That more was the Federal Bill of Rights.
Thank you. We are now ready for your questions.
All right, thank you very much. So since we're talking about rights, how do I distinguish something that is good for society and a good to have versus a right and must be protected at all costs? How do I distinguish that?
So first of all, from what we've seen throughout history, this changes. What is thought of as good for society now is much different than what was good for society back when the framers were creating our Constitution. For instance, we have to consider this. There are certain rights that will always be fundamental. As Karl Vaschak put it in his Generation of Human Rights, he said that our political liberties and our political rights are the most important rights that we have. That is the first generation of his human rights. However, we've seen a much greater change in what we consider a right or something that is necessary to put in our Bill of Rights, such as putting in prohibition and then taking out prohibition based on cultural norms and what we thought of as necessary at the time.
We also
Go ahead, Maddie.
We also see this difference when we look at our state bills of rights, and when we look at that, Justice Brandeis reminded us that we need to allow states to be laboratories of democracy. 22 states include education as a positive right. Connecticut is one of them. Aristotle believed that education was fundamental to society, even said that education makes the person whole. We believe that children in our state are entitled to an education, whereas other states may not list this as a positive right.
I think the most poignant place where we see this sort of comparison is in how in the past century, our citizens have fought hard for non-discrimination laws to be passed through the civil rights movement for racial minorities and LGBTQ+ people. However, in the past 10 years, in Masterpiece Cake Shop versus the Civil Rights Commission of Colorado, and in the this past year with the introduction of the case Fulton County versus Philadelphia, we see the balance between our First Amendment fundamental, crucial right to the free exercise of religion and against an establishment of religion. With that 14th Amendment encouragement in the culture of non-discrimination and equal protection in commerce.
Okay, let me turn this in slightly different direction. What rights that are guaranteed under the Bill of Rights can cause a person to lose those rights? Or did I say that right?
Would you mind restating the question?
Yeah, I think I fouled my head up. Sorry. Yes, what can cause a citizen to lose rights that are guaranteed under the Bill of Rights?
Well, in past years, there's been debate over the loss of the right to vote when one is accused of a federal crime, or when one is incarcerated, they lose that right to vote. And that not only is a loss of a great participation in our democracy, but also targets racial minorities, which are incarcerated at a far higher rate and accused of crimes at a far higher rate than white individuals in this country.
We also see the issue of vaccinations, and especially in relation to COVID-19. People have the right to decide for themselves certain notions of health, safety, and morality in terms of healthcare, and in this case, the vaccine. But if we look at the case of Jacobson versus Massachusetts, the federal government has the right to enforce vaccines as long as it doesn't go so far as what is beyond necessary for health, safety, and morality, when the greater good is at stake. So when we have vaccinations that are mandatory in schools, that is for a greater good. So when we're part of a larger society that has to participate in classical Republican ideals, we have to cede some of our liberties to ensure that the population as a whole is protected.
And we even see within schools that children have less of a right to freedom of speech and freedom of privacy than they do outside of schools. So although this isn't a direct loss of this is just something that we understand. For instance, we can look at TLO versus New Jersey, where students are able to have their backpack searched if there's a reasonable doubt that they do have something in there that is against school rules. And we even see freedom of speech getting restricted, such as in Bethel versus Frazier. So overall, we see that there are places where we lose these fundamental rights, or at least have limitations on our fundamental rights.
Canada, you muted.
So what do you think was left out of the Bill of Rights?
I think a positive right to vote should have been included in the Bill of Rights. If we had a positive right to vote, we could overturn the 2013 decision of Shelby County versus Holder. By establishing a pre-clearance for all 50 states, we can get rid of the 27 states which have had unnecessary voter ID laws, purge voter rolls, and the 1,000 polling places that have been closed. Ruth Bader Ginsburg once said that throwing out pre-clearance when it has worked and continues to work to face anti-discrimination is like throwing away your umbrella just because you're not getting wet.
I personally believe, although maybe too progressive for the time, today what we're missing is the right to healthcare. As it stands right now, the United Nations Declaration of Human Rights, that is Article 25 for them. And 63% of Americans in a Gallup poll currently believe that there should be some form of government provided healthcare. And even for our founders, it might not have been too far ahead of their time. Between a correspondence between John Adams and Abigail Adams, John was considering opening a universal hospital for all the soldiers that would be free and public to them, to which he was concerned about the cost. And Abigail responded to that in correspondence by saying, a great cost, but a greater opportunity. So we can even see that our founders would have started to have those ideas, and they even supported promoting general welfare of our people. And therefore, I believe that this is very fundamental to where we stand right now.
While Griswold versus Connecticut recognized certain penumbras of privacy that exist within the Constitution, showing that the framers had a clear intention for there to be the protected right to privacy, such as in the First Amendment, the Third Amendment, and the Fourth and the Fifth Amendments, I believe that a positive right to privacy, with the word privacy explicitly stated, would provide greater protections to our right to privacy, and we would no longer have to rely so heavily on judicial review to protect that right, as judicial review has expanded it as the technology has evolved through cases such as Kylo, Riley, and Carpenter.
Do you
I want to explore that as an idea. Sorry, Richard, because I wonder, is there any difference in rights that are established by the amendment process versus court decisions? Wouldn't we still be dealing with the same Kylo issues, because there's no way we could write a constitutional amendment that would capture all new technology?
I happen to agree with Thank you. I happen to agree with the statement that the judge just said. However, there are certain issues that would have been solved by amendment. If we look at the Equal Rights Amendment, there are so many issues that go in front of our courts that if we pass this 1923 amendment that was bipartisan, passing through the Nixon and Carter administrations, that we would have been able to solve. And therefore, I believe, yes, although a right to privacy would have been hard to obtain due to the fact that there is this broad standing idea of what is privacy as our new technologies grow, we could bypass a lot of these issues. And even if we look at Boumediene versus Bush in 2008, there was this issue with this idea of due process, how these people were given due process, but only for about 5 minutes and in trials that were not very fair. And now if we look at it, if they were given a negative right to due process, or a due process that said that it had to be the fullest extent of the law, then maybe we would have been able to circumvent that.
I think the distinction between an amendment with a positive right to privacy and the interpretation of the penumbras in Griswold versus Connecticut, may I complete my thought?
Please, thank you.
Is that in Griswold, we're relying on the court to uphold a right that is not enumerated. And this idea of them legislating from the bench and not simply upholding the Constitution, but applying it in a new way for the new culture. We should enumerate it in our Constitution so we have something more substantial to rely on.
All right, wonderful, thank you.
Wow.
Your teacher pops on with a big smile on her face, so that's got to feel good. So, all right, some feedback. All right, Canada.
Wow, that was really excellent, just excellent. Thank you. And it's the first time in 2 days that I've heard somebody say something about contracts would be good. Thank you. And you brought up such wonderful, you just did so beautifully. Everything you said was fascinating and well spoken. And I'm not a bit surprised that you're going to Northwestern. I would not get in now. And it's my 50th anniversary year. So congratulations on getting in. I hope you, I don't know what are you interested in political science too? I think one of you is, aren't you? I know that you're going to be absolutely stunning, sterling citizens, and that's why we do this program. I hope you will teach your families and your friends to pay as much attention as you will and read the paper and vote every chance you get. But I think that we also need more than that from you if you're interested, and that would be to represent us in local, state, or federal government, or be a lawyer or be a judge. We need people who know what the government, how the government is planned and supposed to run here in this country. And I think most people would agree that some people haven't shown that very well lately. So I would be very, very happy to see any one of you representing us in the future in some fashion or another. And I'll be very happy sitting in my rocking chair in my nursing home knowing that you've taken over. So, and best of luck to Northwestern. They're lucky to get you.
I will echo everything that Candida said. I would just also add that Northeastern sounds like they're going to be getting some good talent up there. Absolutely. As well. So you all just did an outstanding job. I was impressed at the depth of knowledge that you brought to this discussion in your presentation. And just absolutely thrilled with the comfort level that each of you had in answering the questions. You were pulling out references to cases that you didn't mention in your opening presentation. It was really good. I think you all should be very proud of yourselves. Congratulations. Thank you.
Yeah, thank you all very much. It was a great start. And what I will highlight, and it seems so simple, but what I will highlight is you all listened to the call of the question, both
yeah,
that was given to you as well as the questions we were asking you.
Yep.
And you answered those questions.
Yep.
And you brought in authority and you talked about what you want to talk about. But so often folks in these type of competitions will get so wrapped up in showing off that they fail to actually answer the question. You did both. You answered the question and you showed off. And so that was well done. Enjoyed it. Congratulations. Breathe a sigh of relief. We're done with the day. This was a great one to end on. So thank you very much.
Thanks. Good job.
Thank you.
Thank you. Thank you.